Hello, everyone. Welcome to another episode of UCS podcasts. Time and again, we at UCS, through our podcasts and newsletters, have voiced out that the importance of the POSH Act in the workplace is paramount, as it helps to create a safe and comfortable work environment for everyone. And yet, after a decade of the law being enforced, several organizations still fail to comply, or if they do, the right procedures are not followed. We have with us today Ms. Anupama Venugopal, Chief Trainer at UCS, who is also the Managing Partner of ABC Legal and Dr. Kayanthal Associates. She is a corporate lawyer with over 2 decades of experience in law. Hi Anupama, it's nice to have you back.
Hi Kaveri.
Anupama, recently we read about the decision of the Industrial Tribunal Rouse Avenue Court at New Delhi in the Standard Chartered Bank POSH case. Well, it's been all over the social media where a conversation between two employees apparently got in the hands of the aggrieved woman. She approached the IC to look into the matter, and since the IC did not respond, she approached the management headquartered in the United Kingdom. Finally, when the IC took up the case and the respondent also participated in the inquiry proceedings, and just before the IC could conclude the proceedings, the organization accepted the respondent's resignation. Well, was this right? Can a company accept the respondent's resignation when a case is ongoing against him?
Yes, Kaveri, I also read about it. And I think the court rightly observed that the IC lacked required knowledge and was not vigilant in the way it followed the process. I strongly feel that organization in this particular case has acted with a malified intention. And the reason I say that is because the organization was well aware that an inquiry was on against him for certain uh, accusations related to sexual harassment. And in spite of the fact that the inquiry was not complete, they proceeded to accept his resignation, which means that the organization had scant respect for the fact that there was a victim who had registered a case, and they knew very well that if they accepted his resignation, they will not be able to give him any punishment. And I think it's a wrong example for any organization to set. It's a totally different story, of course, if the organization had accepted the resignation before the complaint came on record, but the same does not apply when actually the inquiry is going on. So, on the whole, there is a malified intention of the organization.
I believe the court also directed the Delhi Commission for Women of NCT and the Women and Child Development to control seminars, impart legal knowledge to the ICC, to create awareness, and to enable employees to know their rights against sexual harassment at workplace. Because the court also felt that it was crucial for the Delhi Commission for Women to focus on substantive actions rather than superficial gestures just for the sake of publicity. So, what do you think about this? Do you think it was right on the court's behalf to also blame the Delhi Commission of Women?
Let me take up your questions on the two parts that you asked. Yes, I think considering the fact, and this is something that I keep repeating often, that this is one of the laws which is not enforced by the government, and as a result, most of the organizations also don't follow it. 10 years now, and I can still show you there's not even an implementation in spirit of even 30% of the act the way it has to be done. And I think that is what prompted the court to direct the Women and Child Department and the Ministry to actually ensure that the act is implemented. When they talk about imparting legal knowledge, creating awareness, basically they're trying to give a direction to them to say there's a law there in force which talks about holding regular awareness sessions, orientation sessions for the internal committee. But unfortunately, for whatever reasons, everyone seems to be sitting complacently over it. So, You know very well, we've had a discussion earlier also before where there have been several cases where organizations have been fined even up to a sum of rupees 2 crores. Either most organizations know about it and still don't bother about it, or they're waiting for the day when they will be hauled up to actually pay such a penalty. I think it's not one of their most important topics in the organizations.
I have a question here, Anupama. Now, considering that employee had, submitted his resignation and the organization also accepted. Now, when the employee goes and joins another organization, will the employer of the new organization be required to adhere to the recommendations from the IC of the previous organization?
As I said, Kaveri, see, the situation is a very gray area here, right? So the law has been brought in with the institution of an internal committee who gives a recommendation to the employer in terms of the action that happens. Now, in the present instance, and I'm assuming the example that you've given just now, the inquiry was going on and they accepted his resignation. So, what happens? Let's assume that the inquiry was going on, they accepted his resignation. The internal committee comes to a conclusion basis whatever is produced before them, and they give a recommendation to the employer saying deduct 2 increments. I'm just giving you a hypothetical situation. Now, can the employer enforce it? He can't, because the person is no longer his employee. Then it comes to the next situation. Can the employer say, okay, I can't do it anymore, now I'm going to tell the new employer to do it? The new employer is not bound by it because he never took up the inquiry, neither was his internal committee involved. And therefore, it is, that's why I said in situations like this, it's important that an employer acts responsibly, and when he is aware that there's an internal inquiry going on, to not accept the resignation. As I said earlier, if the resignation was accepted earlier, it would have been a different situation. And let's say, an incident happens, say today, and the employee resigns 5 days later, his resignation is accepted, and maybe by the 25th day, the lady comes, not 25th, let's say even a month later, a lady comes and gives a complaint against him for sexual harassment. Naturally, at that point in time, the internal committee can take the complaint of the lady and then decide if he's joined another organization to forward the complaint to the other organization, or in the alternative, if he's on his own, then maybe forward it to the police station for necessary action. I hope that answers your question.
Thank you, Anupama. Thank you so much for this informative session. You clarified a lot of our doubts. I'm sure a lot of listeners also would be having similar kind of doubts. Well, ladies and gentlemen, I do hope you found this episode very informative and interesting. Do get in touch with us with your queries, suggestions, and feedback by emailing us at admin@upceedconsulting.com or writing to us on LinkedIn, Twitter, Instagram, or Facebook. We will be back soon with another interesting topic. Until then, wishing you all a great day ahead. Thank you.